first matter. It's case number 66183 in the matter of Robert Ray Smith. It's a compulsory discipline case. Ms. Barrett, would you like to make a brief opening statement, or would you like to just get into your presentation?
I think I'll just go into the presentation.
Okay, you may proceed.
If it please the board, Judith, Director of the Commission for Lawyer Discipline, this is a compulsory case based on respondent's conviction for forgery, third-degree felony in the 403rd District Court of Travis County, Texas. We filed our petition for compulsory discipline on December the 14th, 2021. Respondent was first.
Yeah, I was going to ask if your microphone was on.
Please speak up.
Okay, shall I start over?
Oh, I didn't hear anything.
We filed our petition for compulsory discipline. Can you hear me now?
Yes, thank you.
On December the 14th, 2021. The respondent was personally served with a petition and notice of hearing on December the 15th, 2021 by George L. Castillo, a private process server. Proof of service has been on file since January the 10th, 2022. On or about November the 8th, 2018, the respondent was charged by indictment with count 1, forgery, and count 2, forgery, in cause number D1 DC 18 904235, styled the State of Texas versus Robert Smith in the 147th Judicial District Court of Travis County, Texas. I'm sorry, that's in the 403rd District Court of Travis County, Texas. On October the 11th, 2019, a plea of guilty, admonishments, voluntary statements, waivers, stipulation, and judicial confession was entered in the same cause number, styled the State of Texas versus Robert Smith in the 403rd Judicial District Court of Travis County, Texas, wherein respondent pled guilty to forgery, a third-degree felony. On November 12, 2019, conditions of community supervision were filed in the same matter, wherein the respondent was placed on community service for 3 years in order to receive counseling and treatment as designated by the supervision officer, submit letters of apologies to the victims, Vilma Price, Judge Wahlberg, and Judge Casort within 6 months of sentencing, give 6 TLAP, Texas Lawyers Assistance Program, presentations and provide proof to the probation officer, continue mental health services with a private provider and provide proof to the probation officer, and not practice law for 3 years. On November the 14th, 2019, an order of deferred adjudication was issued in the same cause, wherein the respondent was placed on deferred adjudication community supervision for 3 years. The terms of the community supervision included treatment and counseling, 3-year suspension from law practice, apology letter to the victims, 6 TLAP presentations, continuing mental health services with a private provider, and payment of court cost in the amount of $320.50. At this time, I would offer the following exhibits. Exhibit 1 is a certified copy of the indictment entered in cause number D-1-18-904235, styled the State of Texas versus Robert Smith. Exhibit 2 is a certified copy of the plea of guilty, admonishments, voluntary statement, waiver, stipulation, and judicial confession in the underlying case. Exhibit 3 is a certified copy of the conditions of supervision in the underlying criminal case. Exhibit 4 is a certified copy of deferred adjudication in the underlying criminal case. Exhibit 5 is my original affidavit attesting to the fact that the respondent is the same person as the defendant in the underlying criminal case. And Exhibit 6 is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, indicating that respondent is licensed but not currently authorized to practice law in the state of Texas. and Exhibit 7 are certified copies of prior disciplinary judgments. One was an agreed judgment of private reprimand from 1998, and the other is an agreed judgment of active suspension for 5 years based on the same facts as the criminal conviction. This time, I ask that all exhibits be admitted.
Ms. Tabor, do you have objections to the admission of any exhibits?
We have no objections, Madam Chair.
Thank you.
Were those admitted?
Yes.
Okay, I'm sorry. At this time, we respectfully request a judgment at this point. Thank you.
Thank you, Mr. Berry. Ms. Tabor, would you like to make a brief opening statement, or would you prefer to just launch into your presentation?
I would, and I promise to just brief at your request.
Thank you. You may proceed.
Esteemed members of the board, good morning. Thank you for the opportunity to address your concerns regarding Robert Ray Smith. I am Catherine Tabor. I stand before you today in a great deal of gratitude. Gratitude for being able to practice law in the great state of Texas for 35 years. Gratitude to argue in the Supreme Court chambers, my first time. And gratitude for the privilege to represent Robert Ray Smith. I've known Bob Smith for 30 years. First, as a former cast member from the Bar and Grill show. And if you haven't seen it yet, you really should. Then, as our friendship grew into a professional relationship, we started to cover each other's hearings, and then into an informal estates and trust and estates practice. I have had the great privilege to know the creativity, the intellect, the work ethic, and the humanity demonstrated by someone I know personally to be a great lawyer, except for a few bad days. We stand here before you as a result of a petition for compulsory discipline. Section 8.05 of the Texas Rules of Disciplinary Procedure state that when an attorney has accepted probation with or without an adjudication of guilt for an intentional crime, the attorney shall be disbarred unless the Board of Disciplinary Appeals under Rule 8.06 suspends his license to practice law. If an attorney receives probation during the deferred adjudication, which he has, in connection with a serious crime, the attorney's license to practice law shall be suspended during the term of the probation. If an attorney is suspended during the term of the probation, the suspension shall be conditioned upon the attorney's satisfactorily completing the terms of the probation. Those two provisions are why we're here today. We have provided you with relevant information on each of the criteria in the matter of Alfred L. Asasi in our written response, and will highlight relevant supporting evidence in our oral testimony. Mr. Smith's lifetime of good works should not be eliminated by one really bad mistake that was made in great part clouded by a very deep depression. We respectfully request that you consider allowing Mr. Smith to complete his 5-year suspension imposed by the State Bar of Texas and allow him to return to the practice of law.
Do you have more to put on?
No.
Okay.
At this time, we would like to call our first witness, Judge Benton Askew.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, can you hear me okay? All right, I just want to make sure. Good morning.
Good morning.
Will you please state your name for the record?
Benton Askew.
And are you appearing here today subject to a subpoena that I sent you?
I am.
Okay. And did you seek the State Commission on Judicial Conduct's office non-binding advice before agreeing to come here today and testify?
I did.
Okay. What is your current occupation?
I am the Bastrop County Court at Law Judge
Okay. And how long have you held that position?
for almost 28 years.
Are you a licensed attorney?
I am.
And when were you licensed to practice law in Texas?
1986.
Are you familiar with Robert Ray Smith?
I am.
Has he appeared before you as an attorney in your court?
He has.
In the summary we provided, approximately how many times has Mr. Smith appeared before you while you were on the bench?
I believe he had 8 different clients and a number of different appearances with those, but probably 10 cases over those clients, but different appearances on each of those.
And do you recall over what time period those 8 clients and 10 or so cases were?
Yes, I believe the first one was in 1997 and the last was in 2013.
And what are your recollections or impressions of those matters that were presented before you during that reference time period?
Well, when you first contacted me, my first impression was I remember Bob Smith. I don't remember any specific cases. So I started looking, and none of those cases really rang a bell with thousands of misdemeanor cases that I've heard as part, and then with general jurisdiction. Generally, the things you remember are the bad lawyers, the ones who are not respectful, or the ones who present things improperly, maybe are aggressive and inappropriate. Those are the ones you remember the most, and I don't remember any specific thing like that other than that Bob Smith was always courteous and prompt, always handled his affairs and represented his clients well. Specifically, certainly I never remembered anything bad that would have raised a red flag.
Like the story you told me yesterday?
Right.
Do you have, I'm sorry. Were you contacted this year to assist Mr. Smith in finding a bar association to hear his talk on what happened to him and what not to do as part of his community service?
I was.
And did you assist him in securing a speaking engagement at the Bastrop County Bar on February 17th, 2022?
Yes,
Did you attend Mr. Smith's presentation to the Bastrop County Bar?
I did.
On the February 2017?
I did.
And what were your impressions of Mr. Smith on that evening, including the talk that he presented to the Bastrop County Bar Association?
He came early. He visited with all the members of the Bar Association who attended, getting to know them, talking with them. He made his presentation. He then stayed for the meeting. He then stayed after the meeting and visited with people. It was a very interesting topic, so very personal, and turns out he had known someone from law school that they had not seen since law school, and they visited, they talked about things, talked about his frame of mind and why he had come. So he came early, stayed late.
What were your impressions? I'm sorry, I saw. What did his presentation and your interaction with him mean to you? What did that show you?
Well, sometimes as a religious person, and I'm also ordained, I sometimes draw these things back into a religious standpoint, and I was frankly a little nervous and awestruck by a situation where somebody was going to have to publicly talk about, in religion sometimes we want to talk about our standards and how we've lived up to them, and so much of it is about when we don't. And that someone was going to have to be so raw and open about not living up to certainly well-recognized standards, but also his own standards. And how do we deal with that? With remorse. How is somebody dealing with that? How are they going to talk about that. It made me a little personally nervous because it was going to take a lot of courage unless he had his fingers crossed behind his back. And so I was really into wanting to hear what he was going to do. He was personally very open about it. He answered a lot of tough questions. He really ripped the bandage off, I felt. I really wanted to know, I knew what he did. I really wanted to know who he was. And how someone, in my thoughts, how someone responds to having not lived up to your own standards when you rip off the bandage, and how you respond to that is a lot more of who you are rather than just what you did. And so I was really wanted to know that, and he made a very strong impression on me during that he had done what I had hoped someone would do when we're dealing with things like standing in front of a tribunal. When you think of it religiously, that's a terrifying thing, to stand in front of someone else or a group of other people when you don't have assurances of anything, and all you can do is accept your guilt. And what you do with that, it's really an awe-inspiring thing when you deal with tough love versus mercy and grace and all of those things. And how he presented himself, how he wanted to present himself, throwing himself on his own grenade, so to speak, and how he did that was very touching and moving, and for me personally. And I don't think he knows, but after he left, I had his number from trying to set up that meeting. I was so impressed. I called him, tried to catch him on the drive home, but he didn't have my number, I don't think, and so he didn't answer. And I thought, well, I'll let that go. But I really wanted to talk to him a whole lot more about how he's doing, to pray for him and to see if there was anything else we could do to assist him on that journey, because it was very moving and touching for me as a practitioner, for me who sits on a side where I have to judge who somebody is based on what they've done is a very fascinating and compelling for me.
Just one more question. Having observed him over time, as you have, and having experienced, knowing what happened and then experienced that talk, is there anything else that you'd like to add to the board on behalf of Mr. Smith? Any other impressions of him as an attorney in conclusion?
Yes, I would always be willing, if he were to be allowed to provide any assistance. I would be happy to have him in my court, and if that were a condition, to have him do some pro se work in my court. There are a lot of needs, and if he receives the kind of grace that he's asking, that I would be happy to have him there. And if they saw fit, I can't judge what he did. That's for all the tribunals. But I wouldn't have any misgivings.
Thank you.
Okay.
I have no further questions, Madam Chair.
Thank you. Mr. Berry, do you have any questions for this witness?
I do not, thank you.
All right, Ms. Tabor, do you have another witness?
I do.
May I say something? I understand I was allowed to come in out of term based on another commitment, and I want to thank you all, and thank you for allowing me to do that. Thank you.
Did he get sworn in?
Yes.
Oh, okay, I'm sorry. I missed that. Thank you. Yes, ma'am. Robert Ray Smith.
Mr. Smith, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Will you please state your name for the record?
My name is Robert Ray Smith.
Is that
Do I need to speak up?
a little bit?
Okay. Robert Ray Smith.
It's better, thank you.
Thanks.
Deep breath. What would you like to say to the board?
First of all, I appreciate the opportunity to come here and talk about my situation with you. I wish to apologize to you as a panel and to you as representatives of all of the legal community of this state for my actions. I cannot tell you how wrong they are. And that is something I will live with for the rest of my life. But I need to move forward with that. And to do that, I must take responsibility for what I have done. And I have to proceed with the rest of my life trying to make amends in any way possible for my actions. I want the panel to know not only do I take full, complete responsibility for it today, I have taken full and complete responsibility for it from day one, from the very earliest stage.
So will you please explain what you mean by that? How did you take full responsibility from the very beginning?
The client came to my office, and that's when I learned what had happened, and she wanted a refund. I immediately refunded her the full fee at the time, and as she walked out the door, my memory is not the greatest in the world, but I will remember this for the rest of my life. After she walked out the door, it was like I had stepped outside of myself and looked back on who I had become. I recalled my upbringing, my parents and grandparents, and the values that they instilled in me, and the sacrifices that they made. And I had always tried to live up, but I had failed. I had failed. Almost simultaneously, I received a letter from the district clerk asking for the question of what happened on this. This is what we have found. What do you have to say? Excuse me. And I began drafting a response. In that response, I told everything as it happened, no sugarcoating, no making excuses. I did that. I had not finished it when I think maybe the next day I was passing through Judge Wahlberg's court, and he said something during an interlude that Bob, what's going on? I've gotten an email. I said, Judge, we need to discuss this in your chambers. And he just motioned me and said, come on, we're on a break. So I went into his chambers, and I remember my opening statement. It was, Judge, I'd give $1 trillion to not have to tell you this. And then I proceeded to tell him what I had done, all of the ugliness in it. I was then planning on doing the same thing with Judge Kasurik. Judge Kasurik placed a phone call to me at my office and asked me to come over. I did, and I brought the unfinished response to Ms. Price, the district clerk. She called Judge Kasurik called Ms. Price to come over, and we would discuss, get to the bottom of it. I made a similar statement, like I said, to Judge Wahlberg, and then I told them every grisly, shameful detail on it. When charges were filed, I informed my counsel that I did not want to put up any kind of a defense. Maybe there could have been some kind of defense that says, can you prove that he's the one that sent this email with the forged document to the client? I said, no, I'm taking responsibility for it. This is something I must do. When a grievance was filed against me, I again said everything in this grievance is true. Since all of this has happened, I was placed on probation. And as you heard, one of the terms of probation was that I give presentations about what had happened to me, why it happened. It was to be a cautionary tale, but what I also want it to be is a tale of hope. I want to give a roadmap of how this kind of a situation can happen. And if somebody is in the darkness of depression that I was, a way to get help. And for people who do not have depression, I want them to look at somebody that they may think, and what can I do to help them? I'm cognizant of time, and I'm just trying to get to the basic points, but let me give you one example. Something an average person can do if they recognize a friend or colleague that is exhibiting signs of depression, and that is reach out to them. Something as innocuous as having a cup of coffee with me, striking up a conversation. How are things going with you? And people have done that, and people did that with me. But expect them to say, no, I'm busy, or whatever, to not interact. That's, like I said, that's what happened with people. But in my case, the people says, okay, I offer. With people suffering from depression, you have to do that repeatedly. And eventually, it will get through to them, and they will visit with you. And that's the first chink in the armor that happens. I guess what is guiding me to make my amends is not just to help people, that's first and foremost, but also as part of my own personal healing process and part of my array of tools to combat my depression. And I do not want anybody to be in the situation I found myself in.
No, Bob, could you clarify something? Was it your idea to give six at a minimum TLAP talks about what you did and your steps for self-improvement and to address your own depression and to basically have to bare your soul to the public. Was that your idea as terms of your probation?
It was entirely my idea to do that because I have a unique situation that not everybody can provide to others. I think it would have been better to do that form of community service than to fold blankets at the Salvation Army or help out at an animal rescue organization or anything else. Anyone can do that type of stuff. I wanted to share my experiences so people, again, would not be where I found myself to be.
Okay. I'd like for you to explain the circumstances leading to your actions, but let's do your world in 90 seconds. In the interest of, I know that we went over that in detail in our written response.
Sure.
In the interest of time, I'd like to remind the board of the enormity of your, Nimini slick. Anyway, the enormity of the things you were dealing with, but let's just touch on them briefly.
Okay, but let me first begin that I do not want what I'm about to say to be construed as any kind of an excuse. Nothing happens in a vacuum. We need to know the full story, the backstory. Example I always give is a car runs through a red light and hits another car, causes serious injuries or maybe death. That's the cold hard fact of what happened. But was the driver intoxicated and alcohol or drugs and on the way to another party to continue their type of behavior? Or was it a situation where a person had just gotten word that a loved one was at the hospital in critical condition? The same outcome, people are injured, but I think it provides perspective. And in that said, this is a 90-second at best summary. Not only, and we'll go over into something else, I have a depression is genetic in my family. There's been a member of the last 3 generations that has taken their own life. And we can tell what family line it was. But 2004, my father passed away. 2005, my mother was diagnosed with breast cancer at the age of 80 years. There was also, at that time, a dispute in my family over some land that had been in our family for over 150 years. That was also gut-wrenching for me. In 2009, we were doing some minor repairs on my house, and black mold was discovered. And as we looked into it, it was not localized, it was throughout the house. Long story short, the house was completely gutted. Only the foundation and the roof and maybe 1/3 of the supporting beams and studs did not have to be replaced. There was no insurance to cover this. We moved out of the house in 2009. I poured every dollar just about that I had saved and that I had earned outside of taking care of my family to try to repair that. 2012 is when it was finally completed. In 2012, my son exhibited problems with serious mental health problems, both depression and anxiety. It was so severe we had to remove him from school and place him in a charter school where he received counseling for half the day and did schoolwork for the other half of the day. Also at this time, my mother began to exhibit signs of dementia. And of course, that increased the stress on me, or on the whole family, in fact. In 2015, she was diagnosed with cancer again, and she passed away later that year. In 2016, an attorney that I had worked with on a daily basis for 21 years, we were not partners, I was basically a contract employee. He called me into his office one Friday afternoon and he said, "This is where we part ways." And overnight, the large amount of money that I was depending on from my work with him evaporated. All I had left was a very small practice. I was trying my best to start a new practice from the ground up. I ended up mortgaging my mother's house that I had inherited for finances to not only support my family, but also to try to get my practice off the ground, building a website, hiring somebody to build a website, different things, advertising, what the things that people do to gather business. It did not work well. I was not getting what I needed. My financial problems increased. And the loan I had taken out on my mother's house was equivalent to a second major mortgage. I could not make ends meet. The regular mortgage on my house and the loan I had on my mother's house were delinquent, and they were placed for sale on the courthouse steps, each house within 3 or 4 months of each other. Fortunately, I had some people friends of mine that came to my assistance, and they were not sold. I eventually sold my mother's house, paid off that, took what remained from it, and continued to work. My wife, during this whole time span, she had always had a compromised immune system. The black mold had caused serious problems with her breathing, and could not walk from the bedroom to the kitchen without becoming short of breath. She also had other major medical problems. She had to have surgery in 2011 to find out what was causing problems with her gastrointestinal tract. I'm sorry. Okay.
She got really sick from that.
She did. All right. Around 2017, 18, 19, she developed an infection. We did not know where it was. They gave her antibiotics. Didn't work. They used the most powerful antibiotics. It didn't work. And this scared the heck out of me because my father died from sepsis, and they tried the most powerful antibiotics on this. That's why I feared we were looking at. And fortunately, we found out what it was, and they actually had to go in there and surgically remove the infected tissue on that. But go ahead.
So you were having a pretty tough time for about, 15 years and longer?
Yes, over that course of time.
That's, 20 maybe. So I want to circle back. The gentleman that you worked for 21 years, What were some of the conditions that he promised you, things that he would deliver in exchange for you working for him?
Also, in addition to the salary that he would pay me, he said he would take care of all of my office expenses and all of my professional expenses, which included paying bar dues and taxes, and really any other expense related to the practice of law.
So when you received notices that they had been unpaid and you presented them to him, what was his response?
His response was, "Don't worry about it. I'm taking care of it. I've got this. You focus on your work. I'm going to take care of it."
Okay, so at that time, you believed he was going to pay them.
Yes, I believed he was going to pay those.
And at this moment, on the hot seat, in front of the board, you know that it's your responsibility ultimately.
Absolutely. I'm not blaming him. The buck stopped with me. I should have made sure that it was paid, his statements notwithstanding.
And-
I should have done it.
And in our original response, we said no to that question because,
Okay, because on those, the issues with bar dues, I did not view that as falling within disciplinary proceedings. You know, it was not anything served upon me. There was not any sanction other than, you know, having to pay a late fee when I didn't do that. So I did not realize that was to be considered.
and there was one other that was a private reprimand. And why, since we're on the side topic, why did we not disclose that one?
Perfect candor, I had forgotten about it. It was a minor deal. I had performed all the work to do an uncontested divorce. The only step left was to physically take the client in front of the uncontested docket, prove up the divorce, and that was it. Everything else had been done. There became a communication problem with the client, and she filed a grievance saying that Mr. Smith is neglecting my case. He doesn't return my phone calls. I did, in fact, return phone calls. I won't say that I did returned it one for one, but I did not keep a good log, or really any log, on that. Occasional notes on return call. And my understanding, or my belief, is that's one of the main reasons that I received the private reprimand. And the one of the terms of it was I have a mentor that would help me be organized. And I apologize for that omission. It was not malicious, but it happened. I take responsibility.
Just briefly, does your depressive condition cause distorted views for you?
Oh, yes. But it's not something that happens overnight. And in my case, it's a chemical imbalance is one of it. The stress, of course, plays a role. And a combination of that, in addition to something that has always driven me my whole life, that was initially a positive, became a negative. When I was a teenager, I heard a person give a speech, and he said, remember these 10 two-letter words. If it is to be, it is up to me. And that's what I took to heart, that I've got to be the one that does it. Don't pawn it off on somebody. If you want to advance to a goal, you've got to do it. And that served me well, but it became a negative in that I did not reach out for help, especially in a time where I needed it. It fell upon me to find a solution. And the thought process ingrained in me by my family growing up became distorted. I said, what can I do to do this, or to overcome this problem? I since remind myself that no man is an island. We have to count on each other. I wish I had done that. That's part of my talks with other people, with presentations that I give.
So can you walk the board through what happened on the evening that you did the galactically stupid thing and give them some context?
Yes. Against all the backdrop that I mentioned, and this was at the time when I was worried about my wife's infection situation, I was working late, as I did most nights, to try to keep up. I had to do everything from personally returning phone calls to draft documents to everything. This was an expunction. There was no hard and fast deadline. It got lower priority than what I call the on fire cases, the ones that were a crisis. And it got overlooked and overlooked. What I did was, when this case and the client says, what's happening? Where is my expunction and order of non-disclosure? I lied to her. I said, we've got it. There was a glitch that came up. I've corrected it. It's different things, lies, something my parents would have been totally ashamed of. Eventually, I had run out of lies, so I said, it's done. Everything is signed, filed. Just wait 60 days for everything to get into the computer system to erase your previous charges that were dismissed.
And what was the point? Was this to buy yourself more time to actually do it?
Yes. This had gotten from a lower level to one of the on fire cases. And she said, can I see a file marked copy of it? And at 10 o'clock at night, I said, I've got to figure out a way to buy more time. So I took a previous signature on another document from one of the judges. I cut and pasted it on the draft order. I cut and pasted a stamp from the district clerk's office, made copies of it, emailed that to her. She later went to the clerk's office and wanted to get a certified copy, and that's when everything came to light. That's where my rock bottom became, and that's what led up to the moment where I stepped out of myself, looked at who I had become, and just asked, how did I get there question.
Did it occur to you at that point that there was some kind of a depressive order that had intervened because you didn't recognize your own behavior?
I did a lot of reflecting on many issues, and I saw that I had been depressed, and it had been even worse than normal depression, But I guess I realized it had come to the point that I had to act on that. I called up my psychiatrist, told her what had happened, and we started looking at the medication I had been on, decided that it had lost its effectiveness, and we started trying new combinations of different medicines.
And what else did you do?
Well, I talked things over my wife, and she said, you need to get counseling, not just talking with me about everything. See a professional. So I engaged in the services of a therapist. I visit with her once a week, and she is able to provide an objective view and challenge me and head off any possibility that the distorted thoughts will come back into play, and also to change my thinking from the if it is to be to the no man is an island.
So as part of your response to what assurances can we give that those seeking legal services from you in the future won't get this kind of service, that will be insulated from this kind of misconduct, more intense monitoring of your meds by the psychiatrist, supportive professional counseling, what else?
Also, I am seeing what they call a Stephen minister from my church. That is a person who has had 50 hours of training in helping people that have different types of problems. I visit with him once a week, and it falls into a hybrid category of somebody who can ask what's going on, and if there's something they question, they will question me on it, but also the part of just being a friend. A lot of times we just talk about world events or sports or movies, and it shows that I'm not alone. And there are other friends that I confide to, and I can call them up anytime, day or night, and I just say, I need to talk. They'll talk to me on the phone, or they'll say, let's have breakfast in the morning, or can I stop by your house after work tomorrow? And we do. We talk, helps keep me balanced.
How have you expanded your spirituality?
In AA and most other counseling organizations, but AA, they says you have to say to yourself, there is a higher power as I understand that power to be. It doesn't say what it is, but it's hard to describe. It's something that will build on the very basic part of yourself. It's called spiritual because it deals with your own spirit. I hate to use cliches, but get in touch with it. Get back to who you really are. And that's a very important part of that, and I talk about that in my presentations. There's also other things. One, I have ghosts of my grandparents and parents, and I cannot let them down again. The love I had for them and they had for me, and what they did to work to make me a good person, even though they're not here, I can't let them down. Also, not being a lawyer has deprived me of some things that I found took great pleasure, enjoyment, fulfillment from. I grew up in a small town, approximately 400 people. A lot of people that helped raise me including a lady that took care of me from the time I was 3 days old. They had maybe 4th, 5th grade education, if that. And they would call me up with some kind of a legal question. They couldn't go to some attorney, and they didn't have $100 to plop down for an initial 15-minute consultation. They talked to me. I helped them out. If I had to do some kind of a legal situation for it, it was always pro bono. They couldn't afford it, but I owed it to them. I've lost the ability to do that. And there's personal guilt. This racks my brain, my conscience, my heart daily. I don't know how I could live with myself if I permitted anything to happen to this. And that's something my counselor is working on with me, forgiving myself. And
Sorry to interrupt. We need to take a short break. DPS needs to reset a security setting. So let's take a 10-minute break and we'll resume. You can pick up with your testimony when we come back.
yes, thank you.
Please be seated. Are you ready to continue?
Yes, ma'am.
How much longer do you have with this witness?
Not too much.
I think we have the general flavor. So if you could speed up any areas, we would appreciate it.
Yes, ma'am.
Thank you.
I wanted to follow up on a response that you had after your Zoom presentation, your TLAP Zoom presentation. What response did you have?
I was made a presentation on Zoom. I believe it was the Houston Christian Legal Society, and after I had finished, one of the people that had heard what I did, they sent me, I don't know whether it's basically a text message, but it's something that came up on my screen. He said that I have been debating whether or not to see a psychiatrist from what I'm suffering from. Hearing you speak has made the decision for me. I'm going to see one. That was heartwarming for me.
Mr. Smith, have you complied with all the terms of your probation, both in the criminal matter and the state bar suspension?
Yes, I have the letters of apology I turned in at the first probation meeting. I paid up all my fees. I'm tendering reports from my psychiatrist, quarterly reports to both the State Bar Monitoring Agency and the probation office, and I'm working on my presentations. I've had difficulty because a lot of associations have not been meeting because of COVID, but I'm working on it.
Okay. In our response, we submitted what was marked as Exhibit 6, which showed quarterly reports from Mr. Smith's counselor. I would like to submit that as Exhibit 1, but ask that this exhibit be sealed. They are his counseling reports, but we want to demonstrate to the board that he has complied with an additional step beyond just getting more rigorous
Monitoring.
I can't talk. He stepped it up and did his mental health counseling, and we have the quarterly reports here. Exhibit 2 that is marked in our materials, our response is Exhibit 7, is a report from his probation officer, Kim Mitchell, stating that he has complied with all of his Travis County probation requirements. He's paid all of his fees. The only remaining outstanding requirements will be for him to complete the final TLAP presentations. We have both been looking for venues for that, and during COVID, it's been difficult, but we're still actively doing that.
Did you say that was Exhibit 2?
Yes.
I've got notice of acceleration, notice of trustee sales.
Yes, sir. That's Exhibit 7 in our response, but it'll be Exhibit 2 to for the court. And then Exhibit 3 is marked as Exhibit 8 in our response, and these are the apology letters. Again, they were required as part of his probation with Travis County to Judges Wahlberg, Kasurik, and the district clerk. Do you have any objections?
No objections.
I was going to ask, if you have any objections to any of the three? Ms. Tabor, we were discussing this yesterday with regard to a different issue, but I'm not sure we have the ability to accept things under seal. So we can try to figure out a way to do that, or we can just, take notice that you have proffered quarterly reports from the psychiatrist and that he's fulfilled that condition of his probation and not have you submit the actual reports, whichever you prefer.
If it's going to cause a problem to seal the documents, Mr. Berry and I discussed the fact that it perhaps should be sealed because it's his private medical records and these will be public records. So we just wanted the board to know that he's taken this very seriously, and to the point that he's proffered his mental health records, so to demonstrate to all of you that he's actually doing it and he is approving. So if it's sufficient for the board to take note that he's doing it, if you don't care to read all of his medical records, then that would be sufficient to us. If it would make it simpler for the tribunal.
Let's do this. We'll take note that you proffered them. We'll review them in camera, but let's not make them exhibits to the proceeding. Is that okay with you?
Okay, just on exhibit 1.
Yes.
Okay, that's fine.
Any objection, Mr. Berry?
No objection.
Okay.
It's the exhibit 2 and 3 are admitted.
Thank you. Just in conclusion, what would you like to say to the board in conclusion in terms of, would it be a good vote to keep you in the game? We don't want them to bench you. We want them to keep you in the game. So, Coach, keep me in the game. What are your final words on that?
Okay. To answer your question and trying not to do it in a roundabout way, part of my presentation is, yes, a cautionary tale, but I think even more important is to offer hope to people like that, people that are suffering from mental health problems. And I want it to come across that as horrible of the thing that I did, and as low as I fell into the darkness, there is a way out. And I can say I have this goal of becoming a lawyer again, and that shows a way out. So that's one thing I want to do. And one of the many reasons I'm asking that you exercise your discretion under 8.06, and that provision suspends the license for the balance of the probationary period. However, the state bar suspension goes much longer than that. So the suspension has more teeth in it than normally it might. Again, I messed up so bad. I cannot apologize enough. I want to work on redemption. And after the probation is over and I've done my presentations, I'm going to do that. I'm going to continue doing that. I'm going to tell my story to help others. I don't want anybody to be where I was.
Mr. Berry, do you have any questions for this witness?
I have no questions, thank you.
Do any members of the board have questions?
Mr. Smith, you've not been practicing since you were placed on deferred adjudication, is that correct?
That is correct.
How have you been making a living?
Several ways. I mentioned we have a family farm that's been in our family for over 150 years. It broke my heart, but I had to sell part of the land. I have also been doing some legal assistant work, some for Ms. Tabor and another for a law firm of Neiman and Hire here in Austin. And let me assure you, everything I do is strictly scrutinized. Neiman and Hire know about my situation. They have elected to have me do things like write memorandums, do research, various things like that, but it's closely monitored.
All right, anything else? Any other source of income?
Any other what? Excuse me?
Source of income?
No, not right now.
And the second, final question is two parts. What is your current personal situation vis-a-vis your wife's health, your son's health, your finances, et cetera? And how can we be assured if those stressors either still exist or return, that you aren't going to take shortcuts again in the practice of law?
Okay. My son's situation is improving. He's got a very good counselor right now. He's on the right medication. It's still a struggle for him, but he's making his way through it. My wife still has significant health problems, very significant. She has rheumatoid arthritis. She's got diabetes. She's had 10 abdominal surgeries. As a result, she has adhesions that have adhere from the flesh to the organs. She's having surgery on May the 12th to remove those. It's difficult, but we're going to get through it. And in the brief, I address the safeguards of protecting future legal clients. And what I'm doing is night and day difference. There's a lot of tripwires that will go off before it gets even close to a situation as it was before. However, even more important, I have to do these things. I have to do the counseling, the medication, the support system. I have to do it for myself, because without it, it's not a good life. It's not.
Thank you, Madam Chair.
Mr. Gross, did you have a question?
Do you plan on getting off for,
Absolutely not.
and you've done 4 talks for TLAB?
No, it's been 2 talks. I had a third one scheduled, but it fell during my wife's upcoming recovery period. I am really beating the bushes to find out anything. And if it's not out of line, if any of you know anybody that our group, please.
So you've done 2 6 TLAB talks?
Correct, Your Honor.
Thank you.
Any other questions from the board? All right, any more questions, Ms. Tabor, for this witness?
No, Madam Chairman.
And still no questions, Ms. DeBerry?
No, ma'am.
All All right, thank you, Mr. Smith. I appreciate you coming and sharing your story with us. You can return to the council table.
Thank you.
Your Honor, we have just one more witness that we taped he's in California, returning tomorrow. So we tried the whole 3 months to get him here in person, but Mr. Berry was kind enough to be on the Zoom with us, and so we have both of our questions there, and I've got it all queued up when the board is ready to hear.
Okay, we're ready. Thank you. And thank you, Mr. Berry, for cooperating and getting that done. I know we had some technical issues and trying to present a Zoom witness, so I appreciate you two working together to make it happen.
She's been a dream to work with. I know y'all know this about her, but she was fantastic to work with. This is an unsworn declaration of John Bay, the witness that's about to give his testimony. He does it orally on the Zoom, but I have the sworn declaration, or if he will be available by telephone. So if any of you want to ask him questions after, we have the conference phone all set up, and I have his number, and he's on standby. So if he don't think he'll be shortchanged because he's not here in person, and so I'll have this to offer to show that he was actually sworn.
Are you offering that as an exhibit?
Yes, Your Honor.
Exhibit 4?
Exhibit 4, yes.
Mr. Berry, any objections?
No objections.
Okay, Exhibit 4 is admitted.
So good morning. I am Catherine Tabor, and I'm here with Judith Berry, and our first witness is Mr. John Bay. This is in cause number 6613 before the Board of Disciplinary Appeals, appointed by the Supreme Court of Texas, and it's in the matter of Robert Gray Smith. State bar number 186787070. And Mr. Bay, I believe you had an unsworn declaration under the Texas Civil Practice and Remedies Code, and if you wouldn't mind reading that, sir, and giving us that information.
Yes, I'm providing an unsworn declaration. My name is John Joseph Bay. My date of birth is February 20, 1959. My current address is 5112 Canyon Oaks Drive in Lago Vista, Texas, 78645 in the United States. I hereby declare, under penalty of perjury, that the testimony which I will provide here today is true and correct. I am currently out of state. I am providing this testimony from Clark County, Nevada.
Thank you. Will you please take your name for the records?
My name is John Vay, V-A-Y.
And Mr. Bay, will you tell us what is your occupation and background?
I am an attorney, licensed in Texas, was licensed in 1984. I've been practicing law for approximately 35 years. I'm currently in the process of retiring. I ostensibly practiced in the environmental and regulatory arena, typically before agencies such as the Texas Commission on Environmental Quality, the Railroad Commission of Texas, and various local, state, and federal regulatory agencies. As I said, I've been doing that for approximately 35 years. By way of background, I previously served as the general counsel for the predecessor agency to the TCPQ. I also formally served shortly after graduating from law school in 1984 as a special agent with the Federal Bureau of Investigation, and worked for several years in Quantico, Virginia, as well as the Seattle field office of the FBI before returning back to Texas. And after my service with the state, I served and practiced in the private sector with law firms such as Bart Thomas and Mentors, Kelly Hart and Hallman, and Ian Kiefer. And during those periods of time, I also maintained a solo law practice as well. So I've been in this sector probably for about 35 years. And as I mentioned, I'm in the process of retiring this year.
And are you acquainted with Robert Ray Smith?
Yes, I am.
And will you please tell us how you came to know Mr. Smith and more about that relationship?
Sure. As I mentioned, I served previously as general counsel for what at the time was the Texas Water Commission, which was the predecessor agency to the current TCEQ. I left the agency at the very end of 1991. In 1992, as I said, I entered the private sector and would regularly appear back before the TCEQ representing clients in a variety of capacities. Bob Smith came on to the agency and was an assistant general counsel in that office. I believe he started in 1992, shortly after I had met. My wife also worked at the agency and was assigned to the chief clerk's office, and also worked and served with the commissioners of that agency. I got to know Bob both in a personal, social capacity, but also regularly dealt with Bob involving matters before the agency. Bob was always a straight shooter and somebody who was always accessible and available to answer questions or to facilitate matters before the agency. So I felt both a personal and professional relationship with Bob dating back to approximately 1992. So it's been about 30 years now. Since that point in time, Bob did leave the agency, and he himself also entered private practice, predominantly practicing in the criminal arena. There were occasions where Bob and I would work on cases together periodically, not often, but periodically. I would solicit his assistance with respect to some local administrative or governmental issues. Bob not only understood the types of environmental issues, regulatory issues that I consistently dealt with, Bob previously had worked for the Texas legislature. He'd worked for several agencies, and so he had a good background. So he was a resource that I would occasionally use in my practice to assist some of my clients.
Good. Go ahead.
I was going to say as well, in addition to working with Bob in a professional capacity, there were occasions where, whether they be client representatives or frankly family members, I have a very large extended family, particularly on my wife's side. I have upwards of 20 nieces and nephews, and so there were always the periodic minor criminal issues that come with having nieces and nephews in their 20s. And so I would typically refer those sorts of matters over to Bob. I did not practice criminal law. I was not about to do so. My forte was in the environmental regulatory arena. Bob obviously was an accomplished criminal attorney, so I would refer some of these family members as well as other people to Bob to handle some of these various matters like DUIs, petty theft issues, things of that nature.
Did you mean criminal defense attorney?
Yes.
Okay. And did you have an opportunity to refer others to Mr. Smith for legal work?
Yes. There were a couple of occasions where I was working with Bob on some matters involving clients that I had. I would call them institutional clients, regular, very valuable clients of mine. Bob would provide assistance to me in those capacities, typically in a local government capacity. I won't go into details for confidentiality reasons, but for example, I found Bob with utility, assisting my clients in matters before Williamson County, City of Georgetown, Travis County, things of that nature. Also in that context, I had valued relationships with those clients, and some of the personnel for those clients periodically would have an issue involving, say, a family member that needed some assistance, criminal defense assistance. And so I actually did refer some of my valued clients at a personal level to Bob for him to handle some matters that would arise.
But you felt comfortable enough to refer your high-end clients to Bob to handle those matters?
Yes, completely.
How would you describe Mr. Smith as a fellow attorney?
Bob, at a subjective level perhaps, is extremely intelligent. Bob's very bright. At the same time, Bob is very practical. He is somebody that has a demeanor that I found useful in certain contexts. Bob is sort of relaxed. He's very sincere. He's a very genuine individual, a little bit folksy. And so Bob was a benefit typically in visiting with folks that perhaps did not necessarily want to be presented with a lawyer, a stilted lawyer. Lawyers sometimes can come across arrogant, but Bob always had an ability to kind of break the ice. He engaged in self-deprecating humor, just a genuine individual. And so I found Bob not only to be bright, I found him to be creative. And in addition to his creativity, he was always approachable and had an ability to kind of draw people in and help me and help clients forge what I would consider to be reasonably practical solutions to problems.
What kind of qualities did he exhibit in your observation and work with him as a lawyer?
Bob was always diligent. I found Bob to be thorough. He was thought-provoking, as I said, he was creative. In my practice, he understood the regulatory dynamics. He also had a legislative background, so he understood the policy issues that would come up. He also understood how to work with folks who work at the agencies or the local governments. So he was useful in that capacity to me. So I always found Bob to be trustworthy. He always did a nice job. I obviously would not have referred clients to Bob, or frankly, for that matter, family members to Bob, if I did not have complete trust in his capabilities and his trustworthy as an attorney.
So that was my next question, is the charge, his galactic misstep, was a forgery issue. So at a fundamental level, do you find him to be trustworthy?
I do, notwithstanding this incident. Bob actually came to me shortly after that incident occurred, called me and said he'd like to get together and meet. He obviously described a situation that was frankly a grievous error on his part, a lack of judgment on his part, but he recognized that immediately. He made a colossal mistake. Bob did have some health issues. He had a lot of things going on in his personal life, of which I was aware, involving his wife and his children, his mother. He had some issues involving his home, needing to be, he had mold issues in the home, so he had to go through a reconstruction process. So Bob was under a great deal of pressure, and so I was aware of that. So he called me and went through this process and described this unfortunate circumstance. We had an interesting conversation. I was disappointed in him, but I think he was more disappointed in himself. So he was very sincere about it. He was very contrite. I certainly counseled Bob, but I think he was already prepared to go through the process of acknowledging and assuming and taking responsibility for what he did, apologizing for that, and trying to make amends for that. He really, I think, sincerely recognized that he screwed up. My counsel to him was certainly do the best job he can of trying to rectify this situation. I knew that he would. That incident is not indicative of who Bob is as an individual. It was completely out of character for him. Not to rationalize or justify what he did, because it was a grievous error on his part. I understood, or at least had sympathy for some of the underlying circumstances that he was going through at that time that may have contributed to him making a serious error in the judgment.
But just to circle back, how long have you known him?
About 30 years now.
So is it fair to say you were comfortable with the transfer of trust necessary to refer family members to him for legal work?
I was. I think Bob always did a nice job. I would always circle back with the family members and make sure they felt like they were taken care of and they enjoyed working with him. As I said, he had the type of folksy personality that translated well and made them feel as though he was providing them a high level of service, and he did a nice job for them, all individuals.
And you were, and it's also true for the referrals to your trusted clients.
Yes, same situation there. He never let me down. I got certainly a clear impression that the clients were satisfied with his work ethic as well as the quality of the services he provided, not only in the context of working on some of their administrative issues before local governments, but also as well, as I said, at least one occasion I can recall a client representative having a son who had a criminal law issue, and Bob assisted the client's son and did a nice job. So there was certainly a recognition of Bob's capabilities as an attorney.
So you testified earlier about the counsel that you gave Mr. Smith after he came to you shortly after the incident and told you what had happened. How well has he followed your counsel to your knowledge? And what additional things that do you know of that he's been, what kinds of things has he changed so that he has been able to, right the path and, is my question clear?
Yes, it is.
Okay.
Yes, I think Bob certainly recognized that he made a colossal error in judgment. And to my knowledge, he wrote letters of apologies to the individuals involved. He's tried to make amends. I understand that as part of an agreed suspension of his license, that he agreed to do something which I consider to be very valuable, which is to go, I'll say go on the circuit and make presentations to people, explaining to them some of the things I think the state bar at large is trying to accomplish in terms of counseling lawyers on who may be suffering from depression or going through feelings of anxiety or distress. So I think Bob is stepping forward. He's acknowledged his fault, and he's trying to rectify that. As I said, my knowledge is he's agreed to a 5-year suspension of his license. He also, on the criminal side, is working through a deferred adjudication. My understanding is he's complying with the terms and conditions of that. He has sought counseling. I think he is really taking all the steps that are necessary, not only to acknowledge his fault, but to make amends for that and to further ensure that he's doing things of value, such that this, in my opinion, probably will never repeat itself again. I consider this to be an aberration given my 30-year history with Bob.
And you've also been available to him as a mentor, is that correct? And another not shoulder, men don't cry on shoulders. What's the male equivalent of that?
Well, some men do. Yeah, Bob and I, we connect at a personal level, not only professional level, but at a personal level. And so we can be very frank and candid with one another. Bob has a great sense of humor. He has a quick wit. I enjoy his company. And so we're able to counsel one another just in terms of bouncing issues off each other. And so when he came to me with this particular issue, it was a very serious issue. So he wanted to get my feedback on that. And so I gave him very frank and candid opinion in terms of that conduct. And we had an interesting conversation about, well, what can you do to correct this and fix this so that you can continue to practice law.
How would you feel about working with Mr. Smith in the future, knowing about this?
Knowing Bob as I do, and having observed how he's responded to this incident, and sought, I think, sincerely to correct his mistake. At such point in time as Bob, his suspension is lifted, and I would certainly hope he doesn't have his law license revoked, frankly. I think, from my opinion, I would be pleased to still refer people to him, whether those be clients or family members. directors. I trust Bob. I think he's sincere. I think he has turned the corner. I think he's on top of the issues that contributed to the situation that is obviously the subject of a disciplinary action. So I personally would be pleased to continue to work with Bob in the future, just knowing him as well as I do and having observed his response to this.
Do you feel that the 5-year suspension from the state bar is the appropriate sanction for the mistake?
I do. I mean, I'm not presumptuous enough to suggest to the board what they should do, but I do at a personal level and objectively as well believe that it is an appropriate sanction. I think 5 years is a long period of time, particularly given Bob's age. In fact, Bob and I are the same age, and our birthdays are 2 or 3 days apart, incidentally. So I'm not sure what I would have done if I had ever faced a suspension. My retirement would have come a lot sooner. But Bob has a lot of drive left. I think there's a lot that he can continue to offer his clients. I think a suspension is completely appropriate. I think it's a lengthy suspension. Given the facts and circumstances, I think it was justified. And I see that he's making great strides in dealing with his personal issues and then also trying to make amends for the situation. So I personally believe that a suspension is the appropriate remedy. I don't, at a personal level as well, believe that a revocation of his license is warranted under the circumstances, given what I see to be his advancement, his acknowledgement of his problem, and the commitment that he's made to basically rectifying the past evils.
What else would you like the board to know about Mr. Smith's character, his work ethic, or anything else that you'd like to add?
I would say Bob can still be of great value as a practicing lawyer for the benefit of his clients. At a personal level,
We lost your video, John.
And your voice.
Oh, there you are.
yes, I apologize. Another call came in and for some reason it interrupted the Zoom video, so I apologize for that.
It's a very nice picture.
And so I think that Bob has a lot to offer as an attorney. I would hate to see him lose that opportunity to practice, not only for his sake, for the sake of his family, but it's more than that. I think he could be of value to the bar. I see what he was doing now. I think he's teaching some valuable lessons that could be of benefit to others. By virtue of his self-introspection and his willingness to step out and talk about those sorts of things. But I think he has a lot to offer, and I would certainly like to see him continue in practice. And I think it's justified in wanting to do so. Bob's bright, as I said, he's creative, and I think he has a lot to offer.
Thank you. Thank you for taking the time to share your thoughts, especially on your vacation and being newly retired. I appreciate that. With the board and for supporting Mr. Smith. I have no more questions at this time, and I'll ask Mr. Berry if she has some questions.
I actually just have a couple. Mr. Bay, you testified earlier that Mr. Smith came to you after the incident and confided in you. Did he come to you before or after the client had discovered the forgery?
I believe it was after the fact because I think he characterized it as I made a colossal mistake. I was going to fix it, but I'm in trouble, and I need to talk to you about the situation. So I think that happened pretty quickly in the process. He made an error in judgment. I think the client discovered that at some point shortly thereafter. I think he was presented with obviously what he knew, which is what he had done. And so it was at that point that he called me and said, let's just get together and have a conversation about this because I really made a huge mistake.
Was it before or after criminal charges had been filed? You know?
Before.
Before criminal charges, okay. But after.
Yes.
Okay, thank you. Are you familiar with the sanction guidelines for Compulsory Discipline?
Not specifically, just only in general terms, and at least in the context of this proceeding, I understand that the issue is whether he should be disbarred, but the board does have discretion to affect a suspension in lieu of a revocation. I am aware just, I'm sorry, I'm aware just generally about some of the factors that are typically considered in the context of determining whether, say, a suspension would be appropriate.
Okay, those are the factors that were found in the assessing case?
Yes, I think that's correct, yes.
Okay, so based on those factors, what's the basis for your belief that a 5-year suspension is appropriate rather than responding in this case?
I don't have those factors in front of me, but just in general, I would say that Bob has accepted full responsibility for the mistake that he made. I think he's been contrite about it. He's tried to make amends. He has agreed and he has cooperated and participated throughout the process. He has a deferred adjudication. My understanding means he's complying with the terms of his, the probation that has been affected as part of that suspension. My understanding is that Bob may have paid some restitution. So I think that as well, I don't think Bob has the same type of history of issues with disciplinary actions, things of that nature that were presented in that other case. When I sort of read that case just one time and then compared the facts of that case to the factors that were considered in that case, when it was determined that individual was not entitled to a suspension or a revocation, I believe had the license revoked. As I went through those, I could see distinguishing characteristics where I felt like Bob was a good candidate for a suspension just based on the various factors and considerations that were presented.
Thank you, that's all I have.
I don't have anything further. I've asked you the question about whether you thought it was fair as someone who knew him for 30 years and was a practicing lawyer, and not so much as an expert. I know you've read the case, and but I did. You know, those are fair questions. Certainly, but.
Right, and I'm here testifying as a character witness just based on my personal knowledge of Bob and his capabilities, not as an expert. I'm familiar with the factors just in a general sense, but my personal opinion was that in looking and comparing the facts in Bob's case versus the facts they presented in that other case, in balance, I really felt like suspension was appropriate.
No, and if I were in Judith's Hollywood Square, I would have asked you the same question. So no, I think that they're fair questions, and it's one of those things that lawyers love, right? That there's discretion, and we get to argue about it and present our person's strengths, and pray that it goes our way in the end when there is discretion, and the board has that decision, has that decision. So again, thank you for still being his friend after 30 years and for taking time to testify. It's my understanding that we're going to try this technology tomorrow afternoon, and that we will want you to be available by telephone on Friday morning in case the board wants to ask you questions, because we're pretty sure that they may want to ask you questions.
Fair enough.
And if we need to swear you in better, we'll have a court reporter. So since this is somewhat uncharted territory, we will need for you to be available. We thought that if we got the lion's share of it done, then we would have an artifact of the board.
So that concludes our Q&A. Did board members have questions for this individual?
I don't think we do, thank you. Okay. Do you have any other witnesses or evidence to offer?
I do not. I have a very brief closing.
Okay, Mr. Berry, would you like to close first?
Sure.
Oh, forgive me.
If you could limit it to 5 minutes, please.
Oh, it'll be less than that.
Okay, thank you.
Okay, just very briefly. The board considers all the factors outlined in the SASI in determining whether to suspend Mr. Smith's license for the term of his probation or to disbar him. The board is also charged with the responsibility of hearing the evidence and determining all questions of law and fact. Thus, if the board decides that the respondent has met his burden to show whether he should be disbarred or suspended, I think two of the factors in Sassi weigh in favor of disbarment, especially two of them, and that's the fact that his conduct was directly related to the practice of law and there was damage to the profession. So with that, I'll leave it to the board's discretion. Thank you very much.
Thank you, Mr. Berry. Ms. Tabor, if you could limit your closing remarks to 5 minutes also.
2 paragraphs.
Wonderful.
Thank you. One of my heroes, Buckminster Fuller, said that we live on the learning planet and that the human animal learns by trial and error. If that is true, then my friend and client, Mr. Smith, now has a PhD in the School of Hard Knocks. He's learned a very difficult, but hopefully a valuable lesson going through this incident. I look at cases of attorney discipline, and in some of the cases, I say, what? I would never do that. Yet in some of the cases, I silently say a prayer. And to myself, I say, but for the grace of God go I. Because I'm an overachiever. I'm a perfectionist. I'm human. I'm capable of error. I'm capable of depression, of imperfection. My client and friend has demonstrated his great remorse for this mistake. And it was a big mistake. But it was an aberration, I believe, that his 30-year friend has said, you know, this just isn't like him. He did not gain financially from the transaction. He's done all that he can to rehabilitate the damage that he's done to the legal profession. And Mr. Berry's right. I don't want anybody that's a lawyer to ever do anything to give more fodder to another legal lawyer job, ever. I don't want anybody to have the appearance even of impropriety, but he had a stumble, and he's doing everything in his power as a mortal, as a human being, to make that right. He's put safeguards in place so that he's a better person, and if allowed, he would be a better lawyer. He volunteered to tell his story to other members of the bar, so that if they too were depressed, but maybe they didn't know it, if they too were spiraling out of control, perhaps they could learn from his mistake and save themselves before falling too far. We respectfully ask again that you spare Robert Ray Smith from disbarment and allow him instead to complete his 5-year suspension as imposed by the State Bar of Texas. And we thank you.
Thank you both for your very well-prepared and well-delivered presentations. Does anyone on the board have any further questions for Mr. Smith or counsel?
I have a question for Mr. Berry.
Yes, sir.
A couple of them. I noticed when you listed aggravating factors under Askew, you didn't mention prior discipline. But in this case, Mr. Smith had prior discipline, not at least 2, and not only did he have them, he didn't disclose them in his response. Now, he addressed that in his testimony, and I'm interested in the CDC's position.
Well, one of those was the private reprimand from, I believe, 1998 or something.
Right.
I don't remember the exact date without my notes. And that was a private reprimand. The other one, the 5-year suspension, is based on the same facts as the compulsory is based on.
Yeah, but there's one for non-payment of dues, which he said he didn't recognize as a discipline.
I don't think there was one for non-payment of dues. I think she was, Ms. Tabor was addressing the Blake Hawthorne affidavit that shows some short periods of time where he wasn't licensed, or his license was suspended, which is an administrative suspension. It's not a disciplinary suspension.
So the CDC doesn't view that as an aggravating factor?
Not unless, no, not necessarily. If we had brought charges, if he'd been practicing during that time, and it came to our attention, we could bring disciplinary charges based on that.
Here's my second question. The conviction was October of 2019, but the petition wasn't filed until December of 21. Just what's the reason for the 2-year minimum?
I really couldn't tell you that. I'm sorry, Mr. Cleveland.
I'm Mr. Ogden.
I'm sorry, Mr. Ogden.
I'm considerably better looking than Mr. Ogden.
I'm not going to get into that fray.
There's nothing there that we should be concerned about?
No, it's not. It may have been part of the getting, we don't file them until we can get all the certified documents from the courts and so on. So that's part of the delay. I think COVID was part of the delay getting things. Specifics, I can't tell you for sure.
Thank you.
You're welcome.
Just a very quick
Yes, sir.
question, please. The other Azazi factors,
Yes, sir.
do you think they have overcome the 2 factors you pointed out today?
I think that's the board's discretion to determine that. I think they've addressed most of them.
Do you think an appropriate, does the CDC think an appropriate case that the other Azazi factors can overcome the factors that you pointed out today?
I think it depends on the case, the facts and circumstances surrounding that. I think those are oftentimes important factors. Damage to the profession. To me, the fact that it's directly related to the practice of law is an important factor.
I guess what I'm kind of getting at is in your pleadings, were you aware of these other Azazi factors that we've heard today when you filed your plea?
Yes,
You were
we were.
about the judge who was going to come in and folks like that.
I did not know who the witnesses would be until fairly recently, I think.
But these Azazi factors we've heard from today from their case, were you aware of all of those when you filed your plea?
Was I aware of what their testimony would be?
The gist of their testimony regarding the other Azazi factors.
And I was not aware of what they would address until I mean, with her pleadings, yes. I mean, her pleadings pretty well laid some of those out, so that's when I became aware of them.
Thank you.
Yes.
Mr. Pierre?
Yes, Madam Chair, I'd like to hear from Robert Smith. I have one question.
Yes, sir.
You mentioned in your own testimony that this specific incident, this expungement, was a lower priority and had no deadlines. If that was a factor and you were quite quick in regard to realizing the mistake that you made right here, why did you do what you did? Are you blaming this? I know you talked about a variety of different events, a compilation of what we are today, but specifically, you were cognizant enough to quickly realize, oh, this is a mistake. You also gave testimony that you said specifically that this was not that this was a lower priority. There were no specific deadlines on it. What led to that?
Good question. Recall I was in the process of trying to rebuild my practice from nothing, and there's another mistake that I made, is I would take anything that came in the door. I just had to get as stronger financially as quick as I could. Bad mistake. Regardless of what your income situation is, there's lots of things you should not take. And I lost sight of that, and it became a triage thing. And I used the one, it's a crisis, it's on fire. This one, if I don't do it tonight, I can do it tomorrow. But you see where that led. I'm not sure, have I answered your question, though?
Thank you.
Any other questions from the board?
And I'm not sure who this goes to precisely, Have the injured parties, and I would consider that the judges and the clients involved, have they weighed in on this at all?
They have not. I would say that they probably did during the regular disciplinary case where the 5 years with probation was, 5-year suspension was in.
They did, the judges specifically weighed in during the criminal prosecution in terms of how long the probation or the suspension would be. And
the prosecutors had said they were considering 2, but
okay.
yeah.
The prosecutors were suggesting 2, and Judge Kosuric pushed for 3.
And that's fine.
And that's, of course, you've practiced before her. She's pretty tough, and we said, of course, if that's what you want, then that's fine. So, and then the state bar pushed for 5. So,
Mr. Barry, are you aware of any other situations wherein an attorney has forged the name of a judge or forged the signature of a judge and not been disbarred?
Not off the top of my head. I could research that report if they would like. The only one that comes to my mind that I have personally dealt with, they just, I believe, resigned in lieu of discipline.
Thank you. Ms. Saber?
yes, Matt Martinez, he was given a misdemeanor deferred adjudication. We tried to get that for Mr. Smith, and it was a different DA, and they wouldn't give us a similar deal.
Do you know the status of his ability to practice law, though, not necessarily his criminal
I
prosecution?
believe he's still practicing.
Yeah, and he was trial director for county.
And he rose to be trial director for the county attorney's office in Travis County. That was our frustration with the last DA, that there seemed to be inconsistency in the way that was handled. And anyway, Mace Thurman was the judge involved in the record.
I would just say, since it was done as a misdemeanor, it would not have come before this board as a compulsory case.
Thank you.
But, Mr.
Iglesias?
It's disappointing because the act should not have happened, and yet the 2 attorneys were treated differently. And it seems very unfair.
What I got is fair.
Well, I mean,
Any other questions from the board? All right, thank you. The board will take it under advisement, and you may be excused.